Hi everyone, this is a Barclay Damon live broadcast where we discuss all things L&E, labor, and employment. I'm Ari, let's dig in.
All right, hey gang, here I am, second time. Again, Ari has not gotten a perm, nor has she changed the color of her hair. Yes, it's Rosemary once again, and Ari is still in Italy where we all wish we were. Not necessarily on our honeymoon, but yes, in Italy. So she should be back in a couple of weeks. So you're stuck with, yes, Rosemary Enright again, labor and employment attorney with Barclay Damon and the practice group leader for labor and employment. So you may recall back in February and March, Ari did a multi-part series entitled, Can I Ask That? And she talked about what employers can and cannot say in their job posts, what they can ask on their applications, and during applicant interviews. And we are so lucky to have Jennifer Behm from Berardi Immigration joining us. And she's going to chat with us from an immigration perspective of, can I ask that? And so it's a bonus episode. So we're so lucky to have Jennifer. Welcome, Jennifer.
Thank you, Rosemary. I'm excited to be here.
Yeah. So I think this is your first time joining us on the podcast, isn't it?
It is. Yes, it is.
Oh, well, good. Well, good. So the way we roll, Jen, is you have to share a fun fact. So do you have a fun fact you can share with our listeners so they can get to know you a little bit?
A fun fact. Well, about when I was in undergrad, I lived on a ship for 3.5 months, and I literally circumnavigated the globe. I sailed around the world and went to about 12 different countries. And that was through this really awesome study abroad experience called Semester at Sea. And that just totally projected my love for traveling and international affairs and cultures. And that's also kind of a big reason I started exploring U.S. immigration law. So yeah, I love traveling. I've done a lot of traveling since that time, but that experience for 3 months in my undergrad years, it was just totally pivotal and had a huge influence on who I am today.
I bet. I cannot imagine. So you actually, for those of us who may, not know the sailing lingo, circumnavigate. So that literally means you went around.
Literally went around the globe. Yep. Went to about 12 different countries.
Wow.
Spent about a week in different countries, not in Italy where Ari is this week.
Yeah.
But yeah, I saw a lot of different cultures and did a lot of service projects, and it was really an incredible experience.
Wow. So we will get into the meat of the podcast, but I just have to ask. So I hear that like in the South Pacific, like the waves are crazy. Like a calm day is like a 15 or 20 foot swell. Did you have that experience?
So that stretch of our trip, we went from Japan down to Hawaii and then over to California. And that was probably the stretch of our trip where so many people were seasick and throwing up. I mean, it was definitely a rocky ride.
Yeah.
It was pretty intense. It was definitely intense, but
I would think so. I would, because I've heard that, and I can't imagine, and I can't imagine. So I guess you did get off the ship, because I can't imagine. Yeah, my legs being on a ship on water.
You're so wobbly afterwards,
Exactly.
And even sleeping back on land. Like I remember, oh my gosh, the bed would feel like I'm still rocking, and I'm not on a ship anymore. It took a while for my equilibrium to get reestablished to land.
I bet. So, well, cool. So that's an awesome fun fact. Thanks for sharing.
Let's see. Look into it if you've got college-aged kids in your life.
That's right. And if you're looking to get your college-age kid, out for 3 months, right? There you go.
There you go.
There you go. All right. Well, so let's dig in. Like we said, Jen, this is a bonus issue. We so appreciate you coming on. And as I said, we did the multi-part series, can I ask that? And what we all learned is that there are certain things that you really should not be asking, because it may be a violation of an anti-discrimination law or, wage and hour or something like that. So, putting on the maybe the immigration glasses, if we want to call it that. Let's start with like job posts and job applications. So I'm just going to throw out a couple of, can we ask these questions?
Yeah.
And you tell us. So can an employer state in their job post, so, on Indeed or Monster or something like that, can they post that U.S. citizenship is required, or only U.S. citizens will be considered for a job?
No. The Immigration and Nationality Act forbids employers from requiring U.S. citizenship for employment. The only exception to this might be is if the job has a restriction for U.S. citizens only, because it might be a federal government contract. Like sometimes ITAR comes into play here. But even then, if it's a job that might only have one ITAR contract, we tell employers err on the side of caution, eliminate any language that says you must be a U.S. citizen to be considered.
Yeah, because, it's interesting, Jen, because we see that, a lot, on job applications. And I actually recently, Jen, saw on one of my clients' applications that they actually asked, it was, it said, the question was, are you a U.S. citizen, or are you eligible to work in the U.S.? And then they asked for the visa number on the job
on the
application. Yes.
Oh, that's a big no-no.
Yeah. And so so Jen, when you say it's a no-no, like, so what could happen? Like who enforces, who might come and say that's a no-no, and what might they, are there penalties? What happens?
Yeah, I mean, as far as enforcement goes for something like that, it's kind of an open book, right? Is somebody going to blow steam at an employer for them because maybe they're ticked off that they weren't hired for the job after going through an interview process? Could be like a whistleblower type of effect. I would say it's usually the Department of Labor that's chasing employers who aren't abiding by these sorts of requirements, and having these missteps. Monetary fines can come into place, but at the end of the day, if there's a violation and you're caught, an employer is opening their door for audits and sanctions and monetary fines. You want to eliminate that. As a U.S. employer, you don't want to open up your door to the DOL or any government agency to come knocking and trying to catch you for doing something wrong.
Exactly. Well, and it's funny you say that, Jen, because that's exactly what we talked about in that multi-part series. We said, listen, the last thing you want is somebody coming in, going through all of your records, because even though you think you've got everything in order,
they'll find something.
They're going to find something. They're going to find something. That is exactly right.
Yeah. And it's important to know, even if it was unintentional, or it was, you have language that's a no-no because somebody just didn't know and they weren't really trying to come at it from a place of discrimination or malice, that the government doesn't care about that, right? You can't claim, oh, I'm so sorry, I didn't know, I didn't mean to do that. They don't care.
That's right. Well, it's just like the anti-harassment laws, in particular sexual harassment. It specifically states what your intent was didn't matter. Yep. If it was offensive, then you violated. So same thing here. Very exactly. Cool. Yeah. Ignorance is not a defense, right? Exactly. Yeah. So basically, so what, if anything, Jen, should they even say? And maybe your answer is nothing. It doesn't matter in the job post or the application.
Yeah. I mean, the one thing, if there is no obligation for a U.S. employer to sponsor a foreign national worker. And to clarify, when I say a foreign national worker, I mean someone who is not a U.S. citizen or a green card holder, or even then someone with an open-ended work permit, like a document called an employment authorization document, or EAD card. So if an employer is gung-ho that they don't want to open up the door to sponsorship, they can state, we are not sponsoring foreign national workers for this position. There's no obligation to sponsor a worker. And in fact, the language that the EEOC recommends is this: in compliance with federal law, all persons hired will be required to verify identity and eligibility to work in the United States and to complete the required employment eligibility verification form upon hire. So that kind of takes us into the interview process, right?
Yep.
My best advice is to employers, look, leave it open. You can write, we will not sponsor workers, but anyone who interviews and you're screening them normally, if they're not indicating that they need sponsorship, you can proceed with that. And during the pre-offer interview process, there's 2 questions about work authorization that employers can ask. And they should be worded something like this. So the first could be, employment at our company is subject to verification of an applicant's identity and eligibility for employment as required by immigration laws. Are you authorized to work lawfully for our company? Okay, and then it should be a yes or no question. And then the second follow-up question that should be asked or could be asked is, will you now or in the future require our company to sponsor you for immigration benefits? This is sometimes called sponsorship for employment-based visas, yes or no. Now, it's important because if you're going to ask these questions, that second question in particular, it has to be asked of every applicant. It should be part of the regular interview process. And the danger in not asking that of every applicant is that if you have a recruiter or somebody, again, who might not know better, but is maybe assuming that someone who has an accent or someone who isn't white isn't an American or a green card holder or immediately authorized to work or a foreign national, if you have someone assume that and they're picking and choosing who they're asking those, do you need sponsorship questions of, that can lead to a discrimination claim, right? So you want to be careful if you're going to ask specific questions during the interview process, they need to be asked of every candidate, and it should be part of the regular screening process. It should be part of your procedures.
Right. Wow. You know what? I have to admit, I had not thought about that, Jen. So is it just the second question about the sponsorship, or is it both of them?
I mean, I tend to be conservative,
Right.
and I like my clients to have processes and procedures. So
Yeah.
I say ask both of these questions. These are the 2 questions that are allowed to be asked when it comes to work authorization.
And it's everybody.
It's everybody. It's everybody. It's part of the interview process.
Right. And then if the person at that point answers no or yes, I need sponsorship or whatever they would answer, an employer could at that point, Jen, say, we're not, what would be the right response, Jen?
Yeah. It could be, I mean, if the company knows they're not sponsoring, they could say, we do not sponsor workers for visas, period. It shouldn't be, we won't sponsor you. It should just be, we don't sponsor workers, period.
Got it. Okay. And they're allowed to do that. There's no obligation, right?
Yeah. Now, I think it's also important to note that an employer should not specifically ask for the individual's current work authorization or visa status until after the offer has been extended. Now, Rosemary, that's not to say that some individuals, going back to that second question, might say, oh yeah, for example, maybe I have an open-ended work permit right now. I don't need sponsorship for the next 2 years, but in the future, I'm going to want an H-1B visa. Sometimes they're open books, and sometimes that's a good thing. It allows an employer to keep their options open and have a collaborative conversation about that. But what an employer wants to avoid is pigeonholing a candidate into disclosing that information before an offer has been extended, because that can get them in some hot water.
So Jen, you were just saying, it's great to have this collaborative, relationship or communication or dialogue with the applicant. And you said, so they might say, I'm on this open-ended work visa or whatever it's called for 2 years, but at the end of that, I'll be looking for sponsorship. So let's say, could an employer do this? Could they say, all right, that's fine. Now the individual voluntarily disclosed it post offer, so they've complied with everything you've told them thus far. Could they, at the end of the 2 years, when the employee says, hey, I need the sponsorship, can they say, we're not sponsoring you, and let them go?
Can.
They could?
Yes, they can. There is no obligation for a U.S. employer to sponsor a foreign national worker for a work visa.
Right. So even though they disclosed it and said, I'm going to need one in year 3, so it doesn't matter. They could say, fine, we'll hire you. And then when it comes time for that, say, we're letting you go. And that's it.
Correct.
Yep. Okay.
Correct.
Good. All right.
Yeah.
Well, since you had mentioned that, all right. So just quickly, so we know what we do on what we can do and cannot do on our application and on our website. I love these 2 interview questions, and I think it's brilliant to say, ask them across the boards, and that's it. It's just part of
All
your
about processes, right? Yep. Standard processes.
That's right. And don't ask for any other additional information, like my poor client who actually had on there, give us your visa number and all of this. Yeah, you don't want to.
Yeah, you don't want to collect that up front. And that's collecting that information is where the I-9 form comes into play. We know what an I-9 form is, and that's required of all new hires, whether you're a U.S. citizen, a green card holder, a foreign national. Now, as an immigration attorney, I'm really only getting the questions when it comes to employers completing I-9s for foreign nationals, because oftentimes HR or whoever's doing the onboarding, they're not familiar with the documents that are required to satisfy the I-9 obligations and terms. And again, this is where employers want to be really careful, because when it comes to completing I-9s, employers cannot require specific documents to verify the foreign national's identity.
Oh, really?
Right?
I didn't know that.
They can give guidance, but just like U.S. employees, a U.S. employer can't require a U.S. passport if the employee wants to provide their driver's license and birth certificate or social security card. You can't go to an employee and say, you have to give me X, Y, and Z documents.
I did not realize that, Jennifer. I hate to admit that, but I did not know that.
It's a common, I don't even want to call it a mistake, Rosemary, because the way I see it play out, especially if I'm collaborating with an employer and an employee on a visa benefit, right?
Yeah.
I will then give the extra guidance. Hey, employee, on your first day of work, or hey, employer, here's our approval notice. This suffices for I-9 purposes, this bottom document, or whatever suffices.
Right.
Because I know what these work permit documents are, and I'm familiar enough with I-9s for in the context of a foreign national worker. It's not always that intuitive. And if you've never dealt with foreign national documents before, you might not know exactly what's perfect for I-9 purposes. So something to keep in mind, if there's any doubt about I-9 completion, ask your immigration attorney or ask HR or somebody who is a little bit more familiar to give you guidance if you're not quite sure that something's appropriate or not.
Right. And so what happens, because, for our listeners, just so you know, I have had this happen several times and had I should say my clients have, and I've reached out to Jen and she's helped them. But Jen, let's share with the group, what do you do? You've made the conditional offer, and, a lot of employers, as you know, Jen, will have the employee start. Right. So they start working because they have, is it 3 days, Jen, or whatever?
3 days.
Yeah.
Yeah.
So they have them, so 3 days before they have to produce the I-9 documentation. And so the employee is now started working. And now all of a sudden, Jen, the documents they produce are either expired or they're not appropriate. What does the employer do? What do they do?
So it varies. It depends. Sometimes if there's expired documents, there's certain times that receipt notices to show a pending renewal application might come into play, right? So that's, again, when we're not sure and it's clearly a tricky situation, ask your immigration attorney for further guidance, right? But if somebody's refusing to show appropriate documentation, by day 3, an employer can terminate.
Right.
And they probably should.
Right.
If the employee's not giving any documentation to show lawful work authorization, or documentation that fits within the parameters of what an I-9 will accept for purposes of proving lawful work authorization, an employer can terminate.
Yeah, because as you know, Jen, we had that, and we had an Yeah, and this in these particular instances, the individuals were not turning in the documentation. Oh, I'll get it, or and one of them was, oh, I'm waiting for this document to be sent. And so the question we then had, Jen, was this. I remember it happened to be a woman, and she said, it should be here within the next week, and we called you, and I believe your counsel was, you can't let her work.
No, she didn't have the proper work authorization, unfortunately. And that's the tricky thing when we are dealing with foreign nationals they're waiting on the government to adjudicate a benefit. Government processing times are in the pits right now.
Yeah.
And COVID hasn't helped that. Sometimes, again, a pending application will suffice. And they're on the immigration side. Recently, actually, the government came out and basically said, hey, we know our processing times stink. We're going to allow these expired documents. We're giving them an additional 540 days of extended authorization. And this is an automatic benefit. And I've had some Barclay Damon clients come back to me and say, hey, we had to terminate so-and-so or place them on unpaid leave. They came back to us with this rule. Is this accurate? And I'll say, yes. Again, it seems counterintuitive. It doesn't 100% fit within the I-9 parameters of like list A, list B, list C documents, but it takes my expertise to say, okay, this is the annotation that you're going to write. They have lawful work authorization. You can onboard them again, re-verify, whatever you need to do. So hiring foreign nationals, it can be tricky for I-9 purposes. I wouldn't immediately rule them out if they're not providing those right documents. But, if they aren't providing accurate documentation, you also don't want to keep them on board. Unfortunately, it's almost like a catch-22. You're kind of almost damned if you do and damned if you don't. If you terminate them too early without really looking at it, and they are authorized to work, they can come back and say, you're not giving me, maybe they're going to raise a claim of discrimination.
Right.
And then on the flip side, if you keep them employed and they don't in fact have work authorization, and the government catches wind of that, there could be fines and penalties. So it can be tricky. But that's why you get your trusty immigration attorney on board, right?
That's right. That's exactly right. And just quickly, so because I'm looking at it, I know how busy you are. So just are there any other things that employers should be keeping in mind? So we know what we shouldn't be asking on the job application part of the interview. This has been terrific on the I-9 stuff. I learned a ton. But is there anything else we should be thinking about or mindful of?
Yeah, my biggest recommendation is adopt employment practices and policies that refrain from discrimination and based on citizenship or national origin, whether that's actual or perceived, right? You want to treat all workers and job candidates consistently when it comes to recruitment and interviewing and hiring without regard to their actual or perceived national origin. You just never know. Don't assume that only U.S. citizens are authorized to work because many non-U.S. citizens do have open-ended work permits that don't require employer sponsorship, and they're good to go on day one. They'll fill out their I-9, they'll give you a copy of their open-ended work permit, and they're good to go. So you don't want to make any assumptions. And I think that's my best piece of advice. Don't assume. If I find in my practice, when a foreign national does need work authorization, they're typically forward about that earlier on in the process. And when you have a candidate who's willing to have a productive conversation up front, that can make it easier all around for long-term planning purposes. Those are candidates, when they're willing to share that information, I often find that it can be a productive hire. And maybe an employer doesn't want to immediately rule them out.
Yeah, and I think those the points that you've made, just I personally think apply to the employment relationship in general, right?
1,000%.
I mean, so I mean, if you've got that collaborative, communication, and you're working together, and you're not making assumptions, and you carry that through the employment relationship, you're going to have in most cases,
Yeah.
a productive relationship, working relationship. So that's terrific.
Agree.
So yeah.
Good.
So all right, well, good. Well, Jen, thanks so much for
You
joining
got
us.
it. It was a pleasure. This was fun.
Yeah, it was a lot of fun, and like I said,
Yeah.
I learned a ton. And I'm sure all of our listeners did too. And
Good.
will you come back and join us?
You bet I will. Yep.
All right, good. All right, have a great day, and we'll talk
Thank you.
soon.
You too, Rosemary. Have a
Okay.
good one.
All right, bye bye.
The Labor Employment Podcast is available on barclaydamon.com, YouTube, LinkedIn, Apple Podcasts, Spotify, and Google Podcasts. Like, follow, share, and continue to listen. Thanks. This material is for informational purposes only and does not constitute legal advice or a legal opinion, and no attorney-client relationship has been established or implied. Thanks for listening.